Hi everybody, welcome to ADMA's virtual Compliance and Croissants. I hope that you brought your own croissants because unfortunately I'm not going to be able to give you any over the internet. Today we're talking about advertising and you've joined me, Jeannette Scott, ADMA's Director of Legal and Regulatory Affairs. So in today's advertising session we're just having a little bit of a taste of what we should be looking for in our advertising content. This is also covered in full in ADMA's Privacy and Marketing Compliance course, which is available both face-to-face at various locations across Australia and online. Just check out the ADMA website for further information about the next course. Today we're going to have a look at an overview of advertising laws. We'll be discussing the latest action from the ACCC, the ACCC's regulatory focus in the last 12 months, questions, and then we'll close. Now this session ran for around 45 minutes as a live session, so we'll allow around that same time today, but of course we'll answer your questions as we go. Just a little bit of background about me. As I mentioned, I'm the Director of Legal and Regulatory Affairs at ADMA. I'm a solicitor with an extensive in-house background. I've been working with marketing and advertising teams for more than 15 years now. I'm also a certified compliance professional and I have a strong background in commercial law, so bringing a really pragmatic approach to privacy and marketing. So we'll start with this overview of advertising laws. Essentially, this session is about how to avoid breaking the law. In doing that, you avoid regulatory intervention, you avoid costly fines, but more than anything else, it's about preserving your organisation's reputation. More than that, if you do the right thing by consumers, you may actually make this a point of distinction for you and enhance your reputation instead. When we're talking about advertising laws at a Commonwealth level, we're speaking principally about the Competition and Consumer Act of 2010. That Act contains the Australian Consumer Law, often referred to as the ACL, and it brings across the consumer protection provisions that used to sit in the Trade Practices Act previously. Some of you may be familiar with that. Now, the Act is overseen by a regulator, the ACCC. The ACCC is the Australian Competition and Consumer Commission. The key provisions in that legislation that relate to marketing are those that relate to misleading conduct or advertising, pricing and unfair selling practices, and consumer rights and guarantees. And we'll be having a look at those areas today as we go through. There are other provisions in the Competition and Consumer Act as well that relate to things like product safety, scams, consumer contracts, unconscionable conduct and those sorts of things, price maintenance, cartels, misuse of market power. That, though, is outside the scope of today's webinar. Have a look at those ads on screen. 3 pictures, 3 lots of burgers, or sorry, 2 burgers, 1 taco. How many of us have eaten one of the ones that we see on the left? How many of us have been served those that we see on the right? It's worth remembering that pictures can be advertising or can mislead in and of themselves. We'll also be having a look at other types of misleading advertising today, such as false claims, substantiation, omission, pricing, and we'll also talk about them in the context of prize giveaways and promotions. So we've got to be conscious of what we say and where we say it, and it doesn't matter what media we're talking about either, whether or not it's television, print, social media, online, even on the product packaging itself. If you make a statement that in some way misleads about the quality, the value, the price, the age of the goods, the benefits of goods or services, or in relation to any associated guarantee or warranty, then you're going to be potentially misleading people and fall foul of the law. We'll also have a talk about testimonials, because using a false testimonial is another example of how you may mislead. The very simple test is what is the overall impression. So that's where we need to look at advertising in the context not just of the images, but also of the words that are associated with it and the ad overall. There are specific areas of ACCC concern that come up over and over and over, and they relate to areas such as comparative advertising, bait advertising, drip pricing, discounts, country of origin claims, misleading claims generally, and also premium claims. Just on the premium claims issue, that's where somebody is claiming that their product or service is better than somebody else's. You have to be prepared to address what the basis of that claim actually is. So we're going to look at some of these particular areas of concern as we move through. We should also bear in mind that the ACCC have particular powers. Like most regulators in the advertising and marketing space, they can fine up to $1.8 million per breach for corporations and up to $360,000 for individuals. They can also use banning orders, a substantiation notice, infringement notices, refunds, and public warnings. Now, generally speaking, all regulators will start softly and try and work with an organisation to address a breach. But if the organisation doesn't come to the party, or if breaches then continue, then the fines and the regulatory intervention will escalate. So sometimes you'll see much larger fines than you will in other occasions, and that's really going to reflect whether or not there's been a continued series of behaviour or to what level the breach was in the first place. Essentially though, we want to also make sure that aside from incurring the ire of the ACCC, that we also avoid interaction because of media attention. Most regulators these days are very media savvy. They will put out media releases about breaches, and this of course has the potential to cause reputational damage. On the subject of misleading claims, silence itself can be misleading. So if you don't mention something that's important, if you know something but you sell a product that's unsuitable for the purpose anyway, then that can constitute misleading conduct. So for example, if I was in a hardware store as a salesman, a customer came in and said, this is just the ladder I need to clean my roof with, but you knew that that ladder was too short to reach the standard roof height and also that it was unsuitable for outdoor use, then you may be engaging in misleading conduct by not saying anything and allowing the consumer to purchase the product anyway. Also, if you relay false information, this can constitute misleading conduct as well, even if you actually didn't know that it was incorrect. Now, ultimately, this might go to any penalty that you face, but the question would be, if you didn't know that it was incorrect, then should you have known that it was incorrect? That will be relevant as well. Puffery. Don't know if any of you have heard this term before. It's one of my favourite words, puffery, a mere puffery. A puffery is a wildly exaggerated claim that nobody could possibly take seriously, or a reasonable person couldn't take seriously. And generally speaking, these types of statements are not regarded as misleading. So world's best coffee, one of my previous compliance courses, I advertised as the world's best compliance course. Some might say perhaps that was a puffery. But it came from a series of cases back in the early 1900s where people used to go around selling their wares on cart and horse, making such fanciful claims. And one of them, the carbolic smoke ball case, went before a court who said that the claims made were so wildly exaggerated and fanciful that no reasonable person could possibly have believed them. And from there, the concept of puffery was born. So if you're going to make a really wildly exaggerated claim, it often has an element of humour in it, then you may be protected by the concept of puffery. Comparative advertising. You need to be careful if you're comparing your product with another to make sure that you're comparing apples with apples and not apples with oranges. If you are comparing apples with oranges, then you should be saying as much. Some of you might remember the picture that you see on the screen at the moment of the two bunnies. One of them is Duracell, and many of us may remember that for quite a period of time the other battery in that picture was Everready. Originally Duracell took on Everready and when comparing two batteries, but there was a challenge to that because the two batteries being compared actually weren't the same type of battery. They had different price points and there were different expectations as to their life cycle. So Duracell took a step back and instead they started comparing themselves to a generic battery and just making a general statement that they were a strong brand. Be careful if you're looking to modify the message in your advertisement through the use of fine print. Some people call it disclaimers or terms and conditions. You can't avoid liability by adding fine print. If conditions that you add are too obscure, if the text which you use is too small to be read, if it flashes across the screen in a television ad too quickly to be read, if it's on radio but the voiceover is too quick or too quiet to be heard, then essentially you have failed to modify your advertisement through the inclusion of that fine print because not enough was done to bring it to the attention of the reader or the viewer. And if you don't give it sufficient notice, that means that the fine print fails and the ad will be taken on face value. So you need to make sure that if you're going to add any sorts of qualifications, that you give them sufficient prominence with respect to the size of your headline so that people actually do see that, for example, although a flight may be $500 to Los Angeles, that it's only available between the 1st and 3rd of April 2016 for limited flights. That will modify their impression of the advertisement, and if you put that wording in prominently, that's sufficient to create a different message than that which you would have created if people hadn't been able to read that fine print. I'm just asking the screen to cooperate with me. Okay, pricing general rules. There are some rules around pricing if you're going to have multiple products that can be purchased. So for example, magazines that come out in a series, there might be 100 magazines to the series, then you should include a single total price as well as the part payment prices. And if there's any minimum charge, you should display that as well. So for example, you might have car hire that's available, but there's a minimum of 3 nights, so you would include what the minimum price would be and then what the daily price would be as well. If there's a discount there, then that pre-price discount must have been available for a reasonable period of time, and the basis for discounting must be clear. So it's not possible to put up prices on goods the night before and then put them on sale again the next day and say, was $50, now $20. That's potentially misleading because you haven't had the item on that higher price for a reasonable period of time. So it's something that you need to be conscious of when it comes to pricing. Multiple pricing. This can be a problem because you often find that you have prices on catalogues, on the store shelf, on the item itself when it's scanned at the checkout. So if there is a disparity between those prices, the consumer is entitled to the lowest advertised price. So it's not enough to say that the higher price prevails because that's what you had on the shelf or that's what you had on the scanned item. If there was a lower price advertised, then the consumer is entitled to take advantage of that lower price. Drip pricing. Drip pricing is another form of component pricing. So hotels and airlines are probably good examples of how this might happen. You start off with an advertised price, then as you move through the sales transaction, there are things that are added in that actually increase the price. So for example, a number of years ago, the airlines might advertise $100 flights to Melbourne, but then they would add on airport tax, they would add on fuel tax, they would add on baggage, they would add on meals. For any of those elements that are compulsory, a consumer has no say as to whether or not they become part of the final price. So all of those component parts must be included up front as part of the total price. You can't keep dripping in those options and increasing the price to the consumer. Here's a great example of what not to do. In this case, it's from TPNG. They advertise a low price of $29.99 per month. Now, it was good that they put the minimum charge would be $509.89 based on a 12-month contract. However, what they didn't point out was that that price was only actually available if you bundled that service with your monthly home telephone service. Now, as a result of that failure to advertise the full price, they were fined some $2 million back in December 2013. Bait advertising is another area of pricing that you need to be cautious about. This is the offering of goods or services at a special price to bring people in the door. You can't actually do that unless those goods or services are available for a reasonable period of time and in reasonable quantities. So for example, as happened to me not that long ago, if you see in a catalogue a DVD on sale and you go in to buy it, then you should expect that DVD to be on sale in the store unless there is something there to clearly qualify that offer for you. So in this particular instance, we went into a major retailer. We were told that they didn't have the DVD, that they often didn't have the DVDs that were advertised. It was hit and miss as to which stores got what, that they didn't give rain checks. Now this was clearly a case of bait advertising because there was nothing in the catalogue to indicate that they wouldn't have all DVDs available at all stores. And another comment that they made was that often the stock didn't come in till a week or so after the sale period had started. So this was clearly an organisation that was trying to get people in the door on the basis of great offers, but was actually not following through on their obligation to make those products available to consumers. What is a reasonable period of time and what is a reasonable quantity will really depend on the type of product that you're talking about. So if it was DVDs, you might be talking about tens or hundreds, depending on the size of the store. If it was a $5,000 TV, then it might be one or two per store, and it might be available for a week or two as opposed to, say, perhaps a week. It really depends on the nature of the offer. We should also have a look at guarantees because it's an area that causes a lot of consternation. There's a list there of the things that a consumer is entitled to have guarantees on. So the Australian Competition and Consumer Law sets out that consumers are entitled to guarantees of this nature, and it depends on the type of goods and services. Generally speaking though, it's for personal purchases under the value of $40,000. So it applies to most retail situations. Quite often though we see that people are touting the sale of extended warranties. You have to ask yourself if you're offering one, does that extended warranty actually give the consumer something above and beyond what they would have been entitled to at law? So quite often where retailers fall down is they'll say, oh look, there's 12 months warranty on that television, but we'll extend it for another 2 years and give you 3 years if you buy this extended warranty. Now the Australian Consumer Law actually says that the length of the warranty that you have on an item isn't a specific period. It's going to depend on what that particular item is. So for example, a toaster that you bought at Kmart, it might be reasonable for it to last, say, just 12 months. But if you bought a $5,000 top-of-the-line television, it wouldn't be reasonable for it to last 12 months. The question then is, would it be reasonable for it to last 3 years or 5 years, perhaps longer? And the Act doesn't actually set out specific periods, so it's up to you as the consumer to assert what you believe is appropriate in the circumstances. And if the retailer doesn't agree with you, then it would need to go through to the regulator as the arbiter. But it's something you need to be conscious of if you're in that space to make sure that you're not falling foul of the consumer law provisions by actually offering something which is in breach of the consumer guarantee provisions. The ACCC's made a number of rulings around guarantees, and Hewlett-Packard was one of the organisations to fall foul in that regard. There was an out-of-court settlement that came in a couple of years ago in the order of around $3 million as a result of breaches. Now, they had 6 breaches that came into play for Hewlett-Packard. They had allegedly told customers that they couldn't get replacements for products until those products had been repaired multiple times, that returns could only be provided at HP's discretion, and that the warranty period was limited to a specific or express period after which customers would have to pay for returns. And that third one is an example of what I was just speaking about. If they were telling people there was only a 12-month warranty, when in fact the law says the warranty is what's reasonable in all the circumstances, then HP was potentially in breach of that provision. In addition to all of this, they were accused of not honouring repairs and exchanges for their online store as well, so they had a number of difficulties there. If we move on now to price giveaways and competitions, and just reminding you that today is just really a snapshot of content, so we've got quite a lot of content, we're moving through it quite quickly. These are things that we go into in a lot more detail in our courses. Prize giveaways and competitions, you must be mindful of not misleading consumers. Make sure that you're honest about their chances of them receiving a prize. Be upfront if there's a catch. So for example, if it's a holiday, are school holidays excluded? Must it be taken within a certain period of time? Those sorts of things should all be addressed. There are different laws in every state and territory, and some of them relate to what sorts of prizes you can offer and how you run the competitions. So you need to be careful and check the laws for each state and territory that's out there. Also be careful, because quite often people will put competitions online and not consider the fact that in doing so they actually need to put in some qualification and limit how far the competition reaches. So for example, if I had a competition in Queensland but I put it online, if I didn't say this is limited to residents of Queensland, then I might have a prize winner who's from another jurisdiction. That might increase my costs of transporting the prize to them. It might also mean that I've fallen foul of permit provisions in other states and territories if I haven't got a permit there when I might have needed to. And also I could have fallen breach of overseas laws if I haven't said something in the competition about it being open only to Australian residents. So always make a statement in your details of participation that addresses who the competition is open to. So normally it would be something like open to Australian residents over the age of 18. Sometimes you'll see that particular jurisdictions are carved out from that statement, and that may well be because there could be a permit at play, and either a decision was made not to pursue a permit in that territory, or that somebody's left it too late to actually obtain one. If you're doing a game of chance, we'll have a look at a table in a minute that shows you which jurisdictions you need a permit in and when. But if you're doing a game of skill, you don't need a permit. No Australian state or territory requires you to have a permit for a game of skill. But if there is a game of skill and you introduce an element of chance, then the competition becomes a game of chance. So to give you an example, if there was a, in 25 words or less, answer this question type competition, and you were looking for the best answer, that would be a game of skill. If you then said, well, we're going to take 100 of those answers at random and judge the best from that 100, you've then introduced an element of chance, and you would need to look to the permit requirements to see if you need a permit in the states and territories in which you're operating. If we move on to have a look at the table, I'm just getting the slide to cooperate with me because it doesn't want to change. There we go. This table is correct as at July 2015. So we've got every state and territory set out. You can see that there are no permits required for games of skill. Then for games of chance, we look at prize values of $5,000 and under, or prize values of over $5,000. So in Queensland, we can see that there are no permits required. In New South Wales, for example, we can see that there are permits required in either case, irrespective of the prize value. Same for ACT. But in South Australia and in the Northern Territory, permits are only required if the prize value is over $5,000. A little asterisk there for the Northern Territory though. They do say that if you need a permit, if you already have one for that competition from another state or territory, then that's okay. They will count that permit for you. And when we're talking about competitions today, we're talking about what's generally known as a trade promotion lottery. So that's the free type competitions that organisations use in promotion of their goods and services. There are other sorts of competitions as well, so raffles, art unions, gratuitous lotteries and things like that. But this is the type of competition that most organisations are using most of the time. So it's the subject of our focus here today. We move on now to the latest in the ACCC's enforcement action. Electric Bazaar, that's one organisation who was brought to the ACCC's attention earlier this year. They were fined $100,000. Now they had made false or misleading representations to consumers about refunds and also their liability for faulty goods. So here they've asserted that they weren't liable for goods that were provided. They made false representations about what could be done to fix them or rectify issues. And in doing that, they've fallen foul of the laws in relation to guarantees and warranties. They were fined significantly as a result of that. Clinica International. Now this program related to targeting migrants, and they were offered training and employment with a promise that ultimately if they completed that training and employment they would be able to find permanent residency in Australia. Now the ACCC alleged there that there were false and misleading representations made and also that there was unconscionable conduct because they were targeting new migrants to Australia, people with poor English language skills, and they were getting them to pay over large sums of money on the basis of promises which simply could not be kept. They were looking ultimately at completing a 4-week course and then moving on to a cleaning type of position, but those positions simply weren't available and there was no true qualification that was going to be given to them as a result of the course. They made their misrepresentations in this case in a number of different ways. So there were advertisements that were made, there were oral representations from the staff and agents of clinica, and also there were misleading representations in the actual contracts that they got these people to sign. Next example is Superbarn Supermarkets and the Real Juice Company. Both of them were penalised after making misrepresentations about juices. There were fines totalling over $20,400 with respect to infringement notices issued by the ACCC. So the Real Juice Company had labelled juices and they were sold by Superbarn. There were two juices in question. The first, a 2-litre apple juice, and it said on the packaging, it's produced locally from the freshest quality apples. It's straight from a farm and it's made in Griffin. Now, however, far from being made in Australia with fresh grown apples, it was actually made from reconstituted apple juice concentrate, which was imported from China. So it seems that there were blatant misrepresentations there on behalf of those involved. It is possible that it was a supply chain issue. Perhaps originally these juices did come from Australian apples and they weren't made from reconstituted apple juice. But it highlights the importance of understanding your supply chain and making sure that what was true still holds true if you're continuing to advertise a product. So it's always worth checking a product from time to time, checking your advertising and essentially sanity checking it. Similar thing to do is look at ads that you're bringing in from overseas. If your product sits across geographic boundaries, then say, does this ad hold true in Australia in the same way that it did overseas? So Apple fell foul of that a few years ago when they were talking about 4G availability and the speed at which products would work, when at that time in Australia we actually didn't have 4G at play at all. Just going back to Superbarn and the Real Juice Company, the second juice there was a cranberry juice and a similar sort of thing. It had a label on it. The label made several assertions that included no added sugar, no artificial flavours, no artificial colours, no preservatives. So if you like your juice fresh with nothing else added, it's really just fruit juice. Now, unfortunately, it really wasn't just fruit juice, and it actually had both additives and sugars in it. Now, the companies, to their credit, did cease supply of both of these products when the ACCC's concerns became known, but the question would have been, to what extent were they aware of this misleading information, and to what extent should they have known prior to the ACCC having taken action against them? Okay, move on now to the ACCC's regulatory focus for 2015, so their forward-looking focus. We've had a look at some of the things they've done. What are they talking about, what they want to do? At the start of this year, they have stated that they will again be pursuing truth in advertising. So quite simply, any statement representing your products or services should be true, accurate, and able to be substantiated. There are fines for businesses that mislead consumers. It does not matter whether a false or misleading statement was intentional or not. And here we go back to that overall impression test. Ask yourself, or ask somebody who hasn't seen your advertising perhaps before, so you have an objective view, what's the overall impression of this ad? Have somebody explain to you what do they think they're going to be getting if they purchase this product or service. Are they aware of any limitations, any special conditions, any time constraints on the offer? Ask them to repeat back to you what they think they're getting, and you may find that you see how effective the wording in your ad actually is, and whether or not you need to revisit that fine print and make it more prominent so that any qualifications actually do have the effect of changing the overall impression of the ad. There's also been a great deal of talk this year about comparative websites. Now, the ACCC has put some guidance on their own website for those who are in the comparative website industry. There were previous actions taken by the ACCC, one of them against Energy Watch, who paid over $2 million in penalties, and another against Compare the Market, who paid a penalty of $10,200. Now, they say that the guidance is designed to assist operators and suppliers when making decisions about the nature of comparative advertising websites, but essentially the issues there sat around the fact that they often weren't disclosing vested interests that they might have had in the advice that they were giving. So some of these comparative websites actually do have a relationship, either at law or through sponsorship or partnership, with the products that they are promoting. So they need to be clear to people about that relationship so that people understand that there's a potential for conflict in the advice. Just looking at what the ACCC's guidance was addressing, the report that they have actioned on the industry came out at the end of 2014. So with the advent of comparative advertising, they took a step back, they commissioned a report, and they've identified lack of transparency with respect to the extent of the comparison service, how far across the market does it actually reach, does it include all products, what savings might you actually realise by using the comparison service, how unbiased or impartial or independent is the service, the value rankings that are used, what is the basis for that, the undisclosed commercial relationships, and the content and quality assurance of the product information. So what have they done to make sure that the advice that they've given is actually correct? So we've had a little bit more noise in the press about that too the last couple of months as well, but country of origin claims would be the other area that probably keeps coming back time after time after time. So be very cautious if you are involved in retail or packaging in any way about your country of origin claims. And again, look at your supply chain. If you've got signage in store, and Coles fell foul of this one, they put products under a sign that essentially said Australian grown when those products, fruits, vegetables and almonds, were actually sourced from overseas. So you need to make sure that the signage in store is married up to the origin of the products as well. So it's worth making sure that you have stepped through your product from marketing through to point of sale, and that everybody's on the same page with respect to what claims can be made, the advertising that sits around your product both in market on various channels and on the package itself, how it's displayed in store, how the pricing is communicated, and what to do if you're challenged with respect to a pricing conflict, what to do in terms of warranties and guarantees, and when you're telling people information about those things, what should you and shouldn't you say? So that was the overview that we had for you. Did anybody have any questions? So far I haven't received any, so what I'm going to do now is just give you a quick plug for those of you who are ADMA members. Make sure that you get onto our website if you haven't already done so, and subscribe to our regulatory news. There's a regulatory e-news that comes out once every month. Non-members are welcome to subscribe to this one as well. If you're a member, also make sure you've got a login for our Compliance Hub, which is the compliance section of the Knowledge Lab. Any staff member in a member organisation can get a login for the Compliance Hub, so it's a great resource for all your staff members to have access to as a one-stop shop for all your privacy information in the marketing and advertising space. If you're a member, also don't forget that you can book a regulatory guidance call with me. If you can't find the answer that you're looking for on our Compliance Hub, then just email me, jeannette.scott@adma.com.au, with a brief outline of your question, and I'll be in touch with you to set up time for a chat. Regulatory guidance calls normally go for about 15-20 minutes, and they'll point you to the resources that we have available on our Compliance Hub, or they'll take you through some of the issues that you should be mindful of. So thank you for joining me this afternoon. I hope that you have enjoyed our little foray into the world of advertising, and we look forward to seeing you again at our next Compliance and Croissants. They're held every 3 months, and we have them both face-to-face and online. Watch out the regulatory e-news for invitations. Not all sessions are available to non-members, so if you'd like to talk to ADMA about becoming a member, please just give us a call. For members, we will be making this recording available, and we'll put it on the ADMA website, and we'll give you a reminder about that in the next regulatory e-newsletter when that comes out. Thank you, everybody. Have a great day.